Start with roll call on the left.
Raj Shivik, Kathy Messenger,
Sean Peterson. John Murray.
Carly Stratton.
Ryan Ray.
Sonny Chapman, Marianne Chinati.
And I will appoint Kathy for Lindsay. We have one public hearing on the agenda. Unfortunately, the certified notices were not, the receipts were not handed in, so we will not be opening that public hearing. So if you're here for Z 2018-1415, that hearing will not be tonight. That will be at our next meeting. So we're going to the regular meeting, call the meeting to order. We do have one addition to the agenda, and it's discussion of the American Disability Act improvement to the facade of McDonald's, 796 Norwich Road. So if someone could add that to the agenda under new business. Okay, Tuesday, the public hearing will be moved to Tuesday, November 13th, 7 p.m. It's our regular meeting, second Tuesday of the month. Okay.
Make a motion to add that.
Okay, thank you. Do I have a second?
I'll second it.
All in favor?
Aye.
Any opposed? Any abstentions? Okay, so added as item C. Citizen participation, this would be the opportunity for a community member to have a comment for the commission. The floor is open if anyone wishes that. Okay. So unfinished old business was not opened, so moving on to new business. Z 2018-1436 of the Town of Plainfield Planning and Zoning Commission requesting a text amendment for Section 20, revision of fee schedule. This does require a public hearing, so I'll entertain a motion to schedule that.
I'll make a motion to move that to the public hearing. Yeah, I'll second it.
All those in favor?
Aye.
Aye.
Any opposed? Okay, public hearing, November 13th meeting. And that brings us to what most of you are probably here for. Oh, I'm sorry.
The public hearing has to be December because we have to notify the COGS and the funding. We already did. Okay.
So we're good with November? Okay, all right. So moving on to item B, Attorney Mark Branse is doing a workshop on the roles and responsibilities of land use boards and commissions. Thank you. You guys can move your chairs if you want.
No, it's just the.
I was going to say, it's kind of a bad angle here. I'm okay, but well,
I think we should develop.
yeah.
A little bit. Thank you for coming. By way of introduction, I'm Mark Branse. In another life, I had an honest job as a town planner. I was a planner between 71 and 76, and every time I turned around, there was a legal issue. And so I went to law school to try to master the witchcraft myself, and I tried to be the kind of town attorney that I wanted when I was a public official. I also did serve about a 7-year sentence on the Planning and Zoning Commission in my own town. So I've been on that side of the table. I represent developers, commissions, also citizens associations. Our firm now represents somewhere over 60 towns in Connecticut. So municipal is a big part of our practice. And we do these seminars for free, try to group together some of our client commissions. Hopefully I know there's people here from beyond Plainfield. First question to get some idea who's here. How many Planning and Zoning Commission members? Okay, how many, having trouble hearing me, just move on up to the front, there's plenty of room in the front rows. In literally hundreds of cases, not to substitute their judgment for yours. If your regulation is in accordance with the statutes, if you have the authority to adopt it, if you have what's called substantial evidence to support your decision, if you have expert testimony from which you can deduce certain facts or non-expert testimony in other cases, the court is going to have to uphold you. The major reason why commissions lose appeals is because of a procedural error, not something of substance. The best way, I think, to save money on court appeals is to get the word out in your town that you win them. We had a case in East Haddam some years ago where a wetlands violation, and the violator violated the regulations some years earlier in kind of a big way, and basically said to the commission, sue me. And they didn't. And so a few years later, he did it again. And this time, we did sue him. And we won. And we got a $5,000 restoration plan and $24,000 in attorney's fees and penalties. It was 20 years before anyone in East Hampton violated the wetlands regulations. People know you're serious. People know that you go in to win, then they're less likely to roll the dice and waste your money on an appeal to sort of, see what happens, what comes of it. Okay? So, that make it work? There we go.
Make
Okay.
it full screen, sorry.
Oh, good. All right.
Only because I'm blind.
Well, that's, I'm sure we like that.
There.
You can see I am not generally a PowerPoint guy, and I before I get into this any farther, this PowerPoint was made for me by Bruce Hyde of the Connecticut Agricultural Extension Service, which is part of UConn, and I always give him credit for that because I could never put anything like this together. And you can tell I barely know how to use it. I just know how to hit the little button and make it go forward.
It'll do that.
Pre-application conferences, they're authorized by both statute and by case law. It's a good, you don't have to do it, many commissions do. Allow people to come in before they file their formal application to kind of brainstorm with you, bounce ideas off of you. It's a perfectly good practice. Since I represent developers too, I can tell you that the farther the design is, the farther along it is, the more reluctant a developer is to change it. So if the developer has done all the stormwater management designs and all the grades and designed this thing down to the tiniest little catch basin, and then you say, it would be better if the building was in the front instead of the back. They're gonna push back on you. Understand. So it is a good idea to come in for these informal discussions. What you need to watch out for, though, is to avoid what's called predetermination. It's one thing to say, gee, I'm concerned about a Walmart at that location, and it's even in a preliminary, and a very different thing to say, I don't care what you say, I'll never vote for a Walmart in that location, all right? You've now made a statement that indicates that your mind is made up, right? And we'll talk about predetermination and conflict of interest at the end, whatever time we can. But the big thing about preliminary discussions is make sure that your comments are general and not as to what you will or won't do on particular files. I think it's a good procedure to use. I'll get this now. Okay, so when is a public hearing required of a commission? The answer is there's certain cases where by statute it's required. Re-subdivision by statute, special permits or special exceptions, which are the same thing. Some towns use one term, some towns use the other. Legally, they're the same thing. For wetlands commissions where it's a significant activity, you must hold a public hearing. For wetlands, if you get a petition with 25 or more names of residents of your town, you must hold a public hearing. There are also cases, though, where you may hold a public hearing. Some local regulations require public hearings for any subdivision, not re-subdivision, subdivisions. Others say subdivisions over 5 lots or whatever. You're allowed to do that. Site plan, ZBAs, variance and ZEO appeals always require a public hearing, every time. Pretty much everything a ZBA does is public hearing. I don't think there's anything you're going to be able to do that is not a public hearing. Even the automotive location, the General Assembly made a mess of that statute, but the safe thing is still to use a public hearing for an automotive use location application. Site plans, you can hold a public hearing if you wish to, but warning, site plan is a 65-day time limit. If you don't act within that time limit, or with a 65-day extension, it's automatic approval, which is different from subdivision. Subdivision, if you hold an optional public hearing, it's 65 days to open the hearing, 35 days to close, 65 days to act, with a cumulative 65 days of extensions that are available. So watch out for that with site plan. Many commissions do not realize that. Okay, changes of zoning regulation amendments, zoning map amendments require public hearings. amendment or adoption of your plan of conservation development. And I think we talked about the others already. Wetlands, we talked about significant activity. You can, now, the statutes in wetlands are a little different than the others. The wetland statutes say, thou shalt not hold a public hearing unless it's a significant activity, unless you get this petition by 25 or more residents of your town, or if it's in the public interest to do so, which, come on folks, means you can hold a public hearing anytime you want to as wetlands, all right? You just have to say it's in the public interest to do so. One of the things to watch out for with wetlands, this was a statutory change from a few years ago. If you receive an application, a formal date of receipt for an application, say it's tonight, okay? It's a routine application. It's perfectly obvious that no one would be interested in it. And you say, and the guy says, you know, I really need to get started. Can you approve it tonight? Can you, wetlands folks? Can you approve it the night you receive it? No, no, because you have to allow 14 days for that petition of 25 people. One of our client towns, who should remain nameless, approved an application the night they got it because they thought it was routine. Within 14 days, they got a petition. So they said, okay, they held a public hearing. People came to the public hearing and yelled at the commission, this is a sham. You guys already voted on this. You guys already approved it. And now you're holding a public hearing, okay? So don't get yourselves in that catch-22. It's too bad that people are delayed needlessly, but that is the statute as it's now written. How do you define significant activity by wetlands? All right, everybody, how? What's the definition that you use?
Building lot. Building lot.
A building lot?
Yeah.
Could be, could be. Where do you find that?
Just occurred to me, the neighborhood I live in has a lot of wetlands.
The answer is, a significant activity is defined by the wetlands regulations. That's where you go for the definition, okay? And that definition will be drawn from the state model wetlands regs, which in turn are drawn from the statutes. So that's how you know it's a significant activity, what your regulation says it is, okay? Now, one of the things to watch out for with applications. Suppose the application is incomplete. They didn't pay the fee. They didn't bring in a survey. Whatever it is, okay? It's tempting to just send back, okay? Just say, oh, you know, this isn't complete. Make it complete. Treat all applications as a live bomb. Okay? Set a public hearing if a public hearing is required. Deny it as incomplete. One of our client commissions in Westbrook was having a constant problem where especially a couple engineers in particular were filing these hopelessly incomplete applications. And then as the town planner would identify missing things, it would come in dribs and drabs. They would go to the town engineer for review in dribs and drabs, and they'd hold a public hearing. They'd have to keep the public hearing open because it wasn't ready yet. It was just a mess. And so what they started doing was the planner would make a list of what was missing. They would open the public hearing. They would read the list, close the hearing, and deny it. Start the clock again. It's too bad when you have to do that, but sometimes, and by the way, again, as someone who represents developers, all right, I understand the developer, just file it, just start the clock, just get it in there. I'll get the rest in soon. Don't, for developers shouldn't do that, and you should not encourage it, because you're making more work for yourself, more expense for your reviewers, and more work for your staff. If it's not complete, set the hearing, if the hearing's required, and then deny it as incomplete, let them start again. Word will get out very quickly that you're serious about that. Now, what does the law require for public hearings? There's something called procedural due process and substantive due process. These are both constitutional requirements, both the U.S. Constitution and our state constitution. Substantive due process means that you reached a conclusion that is in accordance with the law. That the decision you reached is per statute for a regulation, that it's within your jurisdiction. It will be very rare for any of you to run into a situation where you're overturned on substantive due process, because it's just hard to do, okay? If you're a zoning commission, as long as you do zoning, if you're a wetlands commission, as long as you stick to wetlands, as long as you stick to your regulations, okay, you're not gonna get caught up in substantive due process. Where you will get caught up is in procedural due process, which is that your decision, even if it's the right decision, was reached in the wrong procedure, okay? The touchstone of procedural due process is called fundamental fairness. That the hearing is conducted in such a way that all the facts are generated, everybody has access to those facts. Some people don't know some things, other people know other things, okay? No one feels intimidated or harassed. Everyone feels that they can be heard. That there's an opportunity to be heard, and that they're being given that they're really being listened to, okay? That's where predetermination comes in. I mentioned that before, where someone says, I don't care what anybody says, I don't care what I hear, my mind is made up. Well, then that hearing is not fair. People are told that they can come and speak, and that what they say will influence the outcome, when in fact it's not true, okay? So that's procedural due process in a nutshell. Now, crowd control. A lot of what I'm going to tell you tonight is for what I call the Walmart hearings, okay? When the room is full and tempers are high, the torches are burning, okay? You may not have to do this for minor applications, but as the lawyer, I'm worried about the ones that are going to go to court, okay? So that's why I'm focusing on those. You have to watch out for an atmosphere of hostility. Watch out for applause and booing. If one side is being applauded and the other side is being booed, there could be an argument that people felt intimidated to speak, that they were afraid to speak. And I have absolutely been in hearings where that was the case, where people who had one viewpoint or the other began to feel afraid that they were going to be maybe harmed or at least laughed at or ridiculed or whatever. So you absolutely have to avoid that. That is the chairman's job. That's why they have to give you a gavel, hopefully. If not, get one. Sir?
One quick question. Could you back that up just back it up one time?
Yeah.
The last conduct hearing so that no one is intimidated, harassed, or disadvantaged regardless of their position.
Yes.
I just want to catch that. I didn't catch that.
Yeah, so the applause, heckling, booing, that kind of thing is very damaging. For the same reason, avoid show of hands. All right, all of you, the law is very clear. The commission is the decision maker. It is not majority rules. One of the things I say to people is, suppose every man, woman, and child in Plainfield voted to take your house. Could they do it? No, of course not. It's yours, it's your property, okay? Majority does not rule in property rights, and when we talk land use regulations, we're talking property rights. We're talking people have certain rights to use their property in accordance with the law, and we cannot take away those rights, even by majority rule. There's a question here.
In reference to due process, we've had some large subdevelopments that have brought in a slew of folks that have extended their due process in speaking time, so to speak. And we've
Yes.
got to a point where we limit everybody to 3 minutes on big projects. Can we limit them to just 3 minutes, or do they have the right to basically filibuster and continue speaking after everybody's done?
I'm actually getting this, but I'll touch on it now since you raised the question. The answer is neither, okay? There was a case almost directly on point here, so we have an answer. It's one of those cases where there is an answer. What happened in that particular case was that the commission said, it was one of those controversial applications, they said, we're going to impose a 3-minute time limit the first time you speak. But after everyone gets their first time at bat, we'll give you a second time without a time limit. And the court upheld that, because the court said, and by the way, the court pointed out that the hearing went on through 3 nights, and by about 9 o'clock on the 3rd night, when the chairman said, anyone else want to speak? No one else wished to speak. So the court said, clearly people did have an opportunity to speak. Now the flip side of that is filibustering. You can require people to stay on point. You can ask people not to repeat what other people have said. And let me sort of move, let me come back to this, because I've got more on this on the outline. I'll probably mess myself up if I don't do it. Edmund versatility, watch out for jokes. One of the famous cases on this was called the Pirozzillo case. Pirozzillo. Name ends with a vowel, okay? Mr. Pirozzillo's expert, George Logan, I don't have to run this case, he's a wetlands guy, he's a nice guy, he's a funny, nice guy. And so the applicant's expert cracked a joke about how Italians love their gardens, okay? And a commission member joked back. Okay? They denied Mr. Pirozzillo's application for wetlands. It went to court, and the judge said, I realize people were probably just joking, but an atmosphere was created where people of Italian descent might have felt unwelcomed or discriminated against or whatever. So jokes and sarcasm do not transcribe well. All right, no. So do watch out for that. The problem with these things, this atmosphere of hostility, is not only can you lose on appeal, such as happened with the Pirozzillo case, but more important, this can be the subject of a civil lawsuit for damages. The highlight case of this was called Thomas versus West Haven. And this, I won't quote from the case because the actual Supreme Court decision is laced with quotes of profanity from the hearing, where commission members were cussing at the applicant. We get people like you, and I mean, it was pretty bad. And they brought a civil rights action seeking money damages from West Haven. And on defense, the town said, look, we can't help it if there were 2 bad apples on the commission. And the response of the court was, you can and you'd better. It is your responsibility to provide a fair hearing. And if you can't do it, we're going to fine your butts, okay? So you really have to be serious about this. Comments should be directed to the commission, not crosstalk. Once people start arguing with each other across the room, it becomes chaotic very, very quickly. Don't ever allow anyone to interrupt a commissioner, and particularly not the chairman. In my opinion, this is especially true for people who I think should know better. Lawyers, engineers, surveyors. One of the things that I did once at a commission, the attorney was getting a little zealous, and he started interrupting the chairman repeatedly. And some of you have heard Jamie's heard me do this, where I'll just say, never interrupt the chairman. I say it really loud. But what we did there was I said to the commission, Attorney Smith seems to be quite agitated, and I understand that. Why don't we table this item until the end of the evening so he has time to collect his thoughts and compose himself? And we went through staff reports and correspondence and minutes and plan of development. We gave him an hour to cool his heels, and believe me, when it was time for him to speak again, he was civil once more. You don't have to stand for that. I realize all of you get paid double time after 10 o'clock. You should not be treated that way. Make sure people are recognized by the chair before they speak. Again, once people start shouting out and stuff, it gets out of hand really fast. This is regard to your question. Keep people on point. I was at a Wetlands Commission meeting where everybody wanted to talk about traffic and about character of the neighborhood, okay? You can cut people off of that. You can say, I'm sorry, you are not in the right place. Where this is, or I don't like it, or when I bought my house, I thought that would be open forever, and all the other things you've heard 1,000 times. I'm sorry. We have to stay focused on the application. One of the things that I have done that I think can be helpful, particularly with wetlands, I might say, is to make copies of the sections of the regulation that have the criteria to be applied and hand them out to the public. These are the topics we're allowed to hear. These are the topics we're allowed to consider in making our decision. Okay? And I have found that to be productive. Not always, but I have found it If you're expecting trouble, have your attorney there. I don't have to run for office. I don't care if they like me. I don't care if they hate me, okay? I'm perfectly happy to be the lightning rod. I'm happy to be the one that says, excuse me, that is irrelevant. Please sit down. Unless you have anything to say, let's move on, all right? Like I say, they don't have to vote for me. Tell people the rules of the game up front so they know what to expect. Although it's not required, we typically allow the applicant to speak first. This is to indulge the quaint notion that people want to know what the proposal is before they tell you they're against it, okay? But it's a fiction, but we honor it, okay? Questions from the commissioner staff, right? Then those in favor, those opposed, those who are neither. Now, I've been in hearings where they allow all the pros to speak, and then all the no's, and then all the questions are undecided. I've also been in hearings where they go one in favor, one opposed, one in favor, one opposed, until one of them runs out. Either way is okay. However you want to do it is fine, all right, as long as you allow people the opportunity to be heard. Make it clear, no shouting, no applause, no booing. People who break the rules will be ejected from the meeting, and under the Freedom of Information Act, you can throw people out of the meeting who are disruptive. Tell them there will be no exceptions. Also keep the applicant in line. A dear friend of mine, another land use attorney, when he does affordable housing applications, he'll actually try to stir up the crowd and try to get them to say racist things so he can use it on the record, okay? Don't let the applicant do that either. The applicant's supposed to be professional and factual and cool, and they're not supposed to be inciting the crowd either. Keep your own commission members in line. This is chairman. In one of my towns, I won't tell you which one, we had one commission member who would just say the most awful things. And I met him for dinner one night before a meeting and explained this to him, you know, why you really can't say things like this. He didn't understand, appreciate it, thanks so much. And we got to the meeting and he did exactly the same thing again. If you're having a real problem with a member, talk to the first selectman, talk to the party chairman, whoever you have to talk to get that person out of there. Because as they learned in West Haven, you get one person who's online like that, and it can cost the town money. If you can't control that person's so unruly. In another one of my commissions, he said at a meeting, I don't care what the law is. I'm not going to allow this. It's like, you cannot have people saying things like that. Okay? That is poison. Avoid the mob mentality. Have police presence if you need them. In one of our hearings, it was for a gravel pit. We had a state trooper present. The crowd mobbed him, pinned him against the wall, and they had to stop the hearing. We reconvened with 3 state troopers. If you need them, have the constable. And if somebody tries something again, have them ejected. Because once it starts to spiral out of control, it will spiral fast. Okay? Have a large room, oversized in fact. What will happen to you is that people in a crowded room will shout from the back. There's this sort of sense of anonymity from the crowd, okay? So you want there to be plenty of room. Use a high school auditorium, whatever it is you got, whatever it is you need. The other thing is make sure that you have an amplification system. People will sit in the very back and say, I can't hear. I can't hear. I can't hear you from the very back of the room, okay? Have a way to display plans. I cannot tell you how many meetings I've been in where you have the easels set up. And either the commission can see it and the public can't, or the public can't and the commission can't. You know, have a board, have something, have one of those roll around big boards that you can pin plans up to so people can see. Because I can't see that, all right? And once you get that kind of disruption, it grows, it never diminishes. Okay, who can speak at a public hearing? Who can't speak at a public hearing? Any ideas?
Everybody can speak.
Everybody can speak at a public hearing, okay? When we do this for Clear in Haddam, they have what they call clickers. People can pick multiple answers. Like one of the answers, the convicted felons can't speak, people from out of state can't speak. Everybody can speak, okay? And so that's easy, everybody can speak. We talked about the applicant going first, proponents, opponents take turns. You may get an intervention, an environmental intervention, or something called 22A-19. I'm not going to get into that tonight, it's too long a topic. If you get one of those, call the town attorney, which I think for all of you is me, or one of someone in Howard Sage. So, by all means, they have the right to participate. An intervener has the right to participate, even if there is no public hearing. Okay? That's what you need to know, and that's why it's in there. You can allow people to speak even if there's no public hearing. Wetlands commissioners, DEEP tells you not to do that. The reason DEEP says that is because the statute says thou shalt not hold a public hearing unless ABC, okay? So they're worried that you'll end up holding an unnoticed and unauthorized public hearing. It's a legitimate concern, but if you've got 2 or 3 people who want to ask a question or something at a wetlands meeting and you haven't set it for public hearing, it's not a significant activity. I really don't think that's much of a problem. Cross-examination, all right? Due process requires you to allow cross-examination of a witness, someone who spoke, all right? Now, if someone stands up and says, I want to cross-examine that witness, chances are it's going to be a lawyer. Doesn't have to be, but chances are it will be. And chances are even better that the lawyer is hoping you'll say no, because then they've got you on appeal. So, Chairman, the way you respond to that is, I want to cross-examine that witness. Well, Mr. Smith, we're kind of a small town. We do things kind of informally around here. We usually have questions asked through the chair. Is that okay with you? Now they have a choice. If they say, well, yes, that's okay with me, they've waived their right to cross-examination. If they say, no, I demand the right to cross-examine the witness directly, let them do it, because you've avoided an appeal, and the truth is, nobody ever got anything good out of cross-examination in an administrative hearing, okay? The only reason they do it is to try to get you to tell them they can't, really. So that's how you respond to that. Again, by the time you have lawyers on both sides, you should have your own attorney there, but just something to keep in mind. Site walks, especially wetlands folks. This is a big one. When you walk a site as a commission, it is a commission. And the reason I'm focusing on that is because the courts are admonished in literally hundreds of cases not to substitute their judgment for yours. If your regulation is in accordance with the statutes, if you have the authority to adopt it, if you have what's called substantial evidence to support your decision, if you have expert testimony from which you can deduce certain facts, or non-expert testimony in other cases, the court is going to have to uphold you. The major reason why commissions lose appeals is because of a procedural error, not something of substance. The best way, I think, to save money on court appeals is to get the word out in your town that you win them. We had a case in East Haddam some years ago where wetlands violation, and the violator violated the regulations some years earlier in kind of a big way, and basically said to the commission, sue me. And they didn't. And so a few years later, he did it again. And this time, we did sue him. And we won. And we got a $5,000 restoration plan and $24,000 in attorney's fees and penalties. It was 20 years before anyone in East Haddam violated the wetlands regulations. When people know you're serious, people know that you go in to win, then they're less likely to roll the dice and waste your money on an appeal to sort of, see what happens, what comes of it, okay? So, that make it work? There we go,
Make
okay.
it full screen, sorry.
Oh, good, all right.
Only because I'm blind.
Well, I'm sure we'd like that. I am not generally a PowerPoint guy, before I get into this any farther, this PowerPoint was made for me by Bruce Hyde of the Connecticut Agricultural Extension Service, which is part of UConn, and I always give him credit for that because I could never put anything like this together. And you can tell I barely know how to use it, I just know how to hit the little button and make it go forward.
It'll do that.
Pre-application conferences, they're authorized by both statute and by case law. It's a good, you don't have to do it, many commissions do. Allow people to come in before they file their formal application to kind of brainstorm with you, bounce ideas off of you. It's a perfectly good practice. Since I represent developers too, I can tell you that the farther the design is, the farther along it is, the more reluctant a developer is to change it. So if the developer has done all the stormwater management designs and all the grades and designed this thing down to the tiniest little catch basin, and then you say, you know, it would be better if the building was in the front instead of the back. You know, they're gonna push back on you. Understandable. So it is a good idea to come in for these informal discussions. What you need to watch out for, though, is to avoid what's called predetermination. It's one thing to say, gee, I'm concerned about a Walmart at that location, and it's a very, even in a preliminary, and a very different thing to say, I don't care what you say, I'll never vote for a Walmart in that location, all right? You've now made a statement that indicates that your mind is made up, right? And we'll talk about predetermination and conflict of interest at the end, whatever time we can. But the big thing about preliminary discussions is make sure that your comments are general and not as to what you will or won't do on particular files. But I think it's a good procedure to use. Yeah, I'll get this again. Okay, so when is a public hearing required of a commission? The answer is there's certain cases where by statute it's required. Re-subdivision by statute, special permits or special exceptions, which are the same thing. Some towns use one term, some towns use the other. Legally, they're the same thing. For wetlands commissions where it's a significant activity, you must hold a public hearing. For wetlands, if you get a petition with 25 or more names of residents of your town, you must hold a public hearing. There are also cases, though, where you may hold a public hearing. Some local regulations require public hearings for any subdivision, not re-subdivision, subdivisions. Others say subdivisions over 5 lots or whatever. You're allowed to do that. Site plan, ZBAs, variance and ZEO appeals always require a public hearing, every time. Pretty much everything a ZBA does is public hearing. I don't think there's anything you're going to be able to do that is not a public hearing. Even the automotive location, the General Assembly made a mess of that statute, but the safe thing is still to use a public hearing for an automotive use location application. Site plans, you can hold a public hearing if you wish to, but warning, site plan is a 65-day time limit. If you don't act within that time limit, or with a 65-day extension, it's automatic approval, which is different from subdivision. Subdivision, if you hold an optional public hearing, it's 65 days to open the hearing, 35 days to close, 65 days to act, with a cumulative 65 days of extensions that are available. So watch out for that with site plan. Many commissions do not realize that. Okay, changes of zoning regulation amendments, zoning map amendments require public hearings. Amendment or adoption of your plan of conservation development. And I think we talked about the others already. Wetlands, we talked about significant activity. Now, the statutes in wetlands are a little different than the others. The wetland statutes say, thou shalt not hold a public hearing unless it's a significant activity, unless you get this petition by 25 or more residents of your town, or if it's in the public interest to do so, which, come on folks, means you can hold a public hearing anytime you want to as wetlands, right? You just have to say it's in the public interest to do so. One of the things to watch out for with wetlands, this was a statutory change from a few years ago. If you receive an application, a formal date of receipt for an application, say it's tonight, okay? It's a routine application. It's perfectly obvious that no one would be interested in it, and you say, and the guy says, you know, I really need to get started, can you approve it tonight? Can you, wetlands folks? Can you approve it the night you're proceeding? No, because you have to allow 14 days for that petition of 25 people. One of our client towns, who should remain nameless, approved an application the night they got it because they thought it was routine. Within 14 days, they got a petition. So they said, okay, they held a public hearing. People came to the public hearing and yelled at the commission, this is a sham. You guys already voted on this. You guys already approved it. And now you're holding a public hearing, okay? So don't get yourselves in that catch-22. It's too bad that people are delayed needlessly, but that is the statute as it's now written. How do you define significant activity by wetlands? All right, everybody, how? What's the definition that you use?
Building lot? Building lot?
A building lot?
Yeah.
Could be. Where do you find that?
Just occurred to me, the neighborhood I live in has a lot of wetlands.
The answer is, a significant activity is defined by the wetlands regulations. That's where you go for the definition, okay? And that definition will be drawn from the state model wetlands regs, which in turn are drawn from the statutes. So that's how you know it's a significant activity, what your regulation says it is. Okay? Now, one of the things to watch out for with applications. Suppose the application is incomplete. They didn't pay the fee. They didn't bring in a survey. Whatever it is, okay? It's tempting to just set it back, okay? Just say, oh, you know, this isn't complete. Make it complete. Treat all applications as a live bomb. Okay? Set a public hearing if a public hearing is required. Deny it as incomplete. One of our client commissions in Westbrook was having a constant problem where especially a couple engineers in particular were filing these hopelessly incomplete applications. And then as the town planner would identify missing things, it would come in dribs and drabs. It would go to the town engineer for review in dribs and drabs, and they'd hold a public hearing. They'd have to keep the public hearing open because it wasn't ready yet. It was just a mess. And so what they started doing was the planner would make a list of what was missing. They would open the public hearing. They would read the list, close the hearing, and deny it. Start the clock again. It's too bad when you have to do that, but sometimes, and by the way, again, as someone who represents developers, all right, I understand the developer, just file it, just start the clock, just get it in there. I'll get the rest in soon. Don't, for developers shouldn't do that, and you should not encourage it, because you're making more work for yourself, more expense for your reviewers, and more work for your staff. If it's not complete, set the hearing if the hearing is required, and then deny it as incomplete. Let them start again. Word will get out very quickly that you're serious about that. Now, what does the law require for public hearings? There's something called procedural due process and substantive due process. These are both constitutional requirements, both the U.S. Constitution and our state constitution. Substantive due process means that you reached a conclusion that is in accordance with the law. That the decision you reach is per statute, per regulation, that it's within your jurisdiction. It will be very rare for any of you to run into a situation where you're overturned on substantive due process, because it's just hard to do, okay? If you're a zoning commission, as long as you do zoning, if you're a wetlands commission, as long as you stick to wetlands, as long as you stick to your regulations, okay, you're not going to get caught up in substantive due process. Where you will get caught up is in procedural due process, which is that your decision, even if it's the right decision, was reached in the wrong procedure, okay? The touchstone of procedural due process is called fundamental fairness. That the hearing is conducted in such a way that all the facts are generated, everybody has access to those facts. Some people don't know some things, other people know other things, okay? No one feels intimidated or harassed. everyone feels that they can be heard, that there's an opportunity to be heard, and that they're being given that they're really being listened to, okay? That's where predetermination comes in. I mentioned that before, where someone says, I don't care what anybody says, I don't care what I hear, my mind is made up. Well, then that hearing is not fair. People are told that they can come and speak, and that what they say will influence the outcome, when in fact it's not true, okay? So that's procedural due process in a nutshell. Now, crowd control. A lot of what I'm going to tell you tonight is for what I call the Walmart hearings. Okay? When the room is full and tempers are high, the torches are burning, okay? You may not have to do this for minor applications, but as the lawyer, I'm worried about the ones that are going to go to court, okay? So that's why I'm focusing on those. You have to watch out for an atmosphere of hostility. Watch out for applause and booing. If one side is being applauded and the other side is being booed, there could be an argument that people felt intimidated to speak, that they were afraid to speak. And I have absolutely been in hearings where that was the case, where people who had one viewpoint or the other began to feel afraid that they were going to be maybe harmed or at least laughed at or ridiculed or whatever. So you absolutely have to avoid that. That is the chairman's job. That's why they have to give you a gavel, hopefully. If not, get one. Sir?
One quick question. Could you back that up just back it up one time?
Yeah.
The last conduct hearing so that no one is intimidated, harassed, or disadvantaged regardless of their position.
Yes.
I just want to catch that. I didn't catch that.
Yeah, so the applause, heckling, booing, that kind of thing is very damaging. For the same reason, avoid show of hands. All right, all of you, the law is very clear. The commission is the decision maker. It is not majority rules. One of the things I say to people is, suppose every man, woman, and child in Plainfield voted to take your house. Could they do it? No, of course not. It's yours. It's your property, okay? Majority does not rule in property rights. And when we talk land use regulations, we're talking property rights. We're talking people have certain rights to use their property in accordance with the law. And we cannot take away those rights, even by majority rule. There's a question here.
In reference to due process, we've had some large subdevelopments that have brought in a slew of folks that have extended their due process in speaking time, so to speak. And we've
Yes.
got to a point where we limit everybody to 3 minutes on big projects. Can we limit them to just 3 minutes, or do they have the right to basically filibuster and continue speaking after everybody's done?
I'm actually getting this, but I'll touch on it now since you raised the question. The answer is neither, okay? There was a case almost directly on point here. So we have an answer. It's one of those cases where there is an answer. What happened in that particular case was that the commission said, it was one of those controversial applications. They said, we're going to impose a 3-minute time limit the first time you speak. But after everyone gets their first time at bat, we'll give you a second time without a time limit. And the court upheld that. Because the court said, and by the way, the court pointed out that the hearing went on through 3 nights. And by about 9 o'clock on the 3rd night, when the chairman said, anyone else want to speak? No one else wished to speak. So the court said, clearly people did have an opportunity to speak. Now the flip side of that is filibustering. You can require people to stay on point. You can ask people not to repeat what other people have said. And let me sort of move, let me come back to this, because I've got more of this on the outline. I'll probably mess myself up if I don't do it. Versatility. Watch out for jokes. One of the famous cases on this was called the Pirozzillo case. Pirozzillo. Name ends with a vowel, okay? Mr. Pirozzillo's expert, George Logan, I don't know if you've run this case, he's a wetlands guy, he's a nice guy, he's a funny, nice guy. And so the applicant's expert cracked a joke about how Italians love their gardens, okay? And a commission member joked back, ha ha, okay? They denied Mr. Pirozzillo's application for wetlands. It went to court, and the judge said, I realize people were probably just joking, but an atmosphere was created where people of Italian descent might have felt unwelcomed or discriminated against or whatever. So jokes and sarcasm do not transcribe well. All right, no, I didn't even see us in here. So do watch out for that. The problem with these things, this atmosphere of hostility, is not only can you lose on appeal, such as happened with the Pirozzillo case, but more important, this can be the subject of a civil lawsuit for damages. The highlight case of this was called Thomas versus West Haven. And this, I won't quote from the case because the actual Supreme Court decision is laced with quotes of profanity from the hearing, where commission members were cussing at the applicant. We get people like you, and I mean, it was pretty bad. And they brought a civil rights action seeking money damages from West Haven. And on defense, the town said, look, we can't help it if there were two bad apples on the commission. And the response of the court was, you can and you better. It is your responsibility to provide a fair hearing. And if you can't do it, we're going to fine your butts, okay? So you really have to be serious about this. Comments should be directed to the commission, not crosstalk. Once people start arguing with each other across the room, it becomes chaotic very, very quickly. Don't ever allow anyone to interrupt a commissioner, and particularly not the chairman. In my opinion, this is especially true for people who I think should know better. Lawyers, engineers, surveyors. One of the things that I did once at a commission, the attorney was getting a little zealous, and he started interrupting the chairman repeatedly. And some of you have heard Jamie's heard me do this, where I'll just say, never interrupt the chairman. I say it really loud. But what we did there was I said to the commissioners, Attorney Smith seems to be quite agitated, and I understand that. Why don't we table this item until the end of the evening so he has time to collect his thoughts and compose himself? And we went through staff reports and correspondence and minutes and plan of development. We gave him an hour to cool his heels, and believe me, when it was time for him to speak again, he was civil once more. You don't have to stand for that. I realize all of you get paid double time after 10 o'clock. You should not be treated that way. Make sure people are recognized by the chair before they speak. Again, once people start shouting out and stuff, it gets out of hand really fast. This is regard to your question. Keep people on point. I was at a Wetlands Commission meeting where everybody wanted to talk about traffic and about character of the neighborhood, okay? You can cut people off of that. You can say, I'm sorry, you are not in the right place. Where this is, or I don't like it, or when I bought my house, I thought that would be open forever, and all the other things you've heard 1,000 times. I'm sorry. We have to stay focused on the application. One of the things that I have done that I think can be helpful, particularly with wetlands, I might say, is to make copies of the sections of the regulation that have the criteria to be applied and hand them out to the public. These are the topics we're allowed to hear. These are the topics we're allowed to consider in making our decision. Okay? And I have found that to be productive. Not always, but I have found it. If you're expecting trouble, have your attorney there. I don't have to run for office. I don't care if they like me. I don't care if they hate me. Okay? I'm perfectly happy to be the lightning rod. I'm happy to be the one that says, excuse me, that is irrelevant. Please sit down. Unless you have anything to say, let's move on. All right? Like I say, they don't have to vote for me. Tell people the rules of the game up front so they know what to expect. Although it's not required, we typically allow the applicant to speak first. This is to indulge the quaint notion that people want to know what the proposal is before they tell you they're against it, okay? But it's a fiction, but we honor it, okay? Questions from the commissioner staff, right? then those in favor, those opposed, those who are neither. Now, I've been in hearings where they allow all the pros to speak, and then all the no's, and then all the questions are undecided. I've also been in hearings where they go one in favor, one opposed, one in favor, one opposed, until one of them runs out. Either way is okay. However you want to do it is fine, all right, as long as you allow people the opportunity to be heard. Make it clear, no shouting, no applause, no booing. People who break the rules will be ejected from the meeting, and under the Freedom of Information Act, you can throw people out of the meeting who are disruptive. Tell them there will be no exceptions. Also keep the applicant in line. A dear friend of mine, another land use attorney, when he does affordable housing applications, he'll actually try to stir up the crowd and try to get them to say racist things so he can use it on the record, okay? Don't let the applicant do that either. The applicant's supposed to be professional and factual and cool, and they're not supposed to be inciting the crowd either. Keep your own commission members in line. This is chairman. In one of my towns, I won't tell you which one, we had one commission member who would just say the most awful things. And I met him for dinner one night before a meeting and explained this to him, you know, why you really can't say things like this. Thank you, didn't understand, appreciate it, thanks so much. And we got to the meeting and he did exactly the same thing again. If you're having a real problem with a member, talk to the first selectman, talk to the party chairman, whoever you have to talk to get that person out of there. Because as they learned in West Haven, you get one person who's online like that, and it can cost the town money. If you can't control that person's so unruly. In another one of my commissions, he said at a meeting, I don't care what the law is, I'm not going to allow this. It's like, you cannot have people saying things like that. Okay? That is poison. Avoid the mob mentality. Have police present if you need them. In one of our hearings, it was for a gravel pit, we had a state trooper present. The crowd mobbed him, pinned him against the wall, and they had to stop the hearing. We reconvened with 3 state troopers. If you need them, have the constable. And if somebody tries something again, have them ejected. Because once it starts to spiral out of control, it will spiral fast. Okay? Have a large room, oversized in fact. What will happen to you is that people in a crowded room will shout from the back. There's this sort of sense of anonymity from the crowd, okay? So you want there to be plenty of room. Use a high school auditorium, whatever it is you got, whatever it is you need. The other thing is make sure that you have an amplification system. People will sit in the very back and say, I can't hear. I can't hear. I can't hear you from the very back of the room, okay? Have a way to display plans. I cannot tell you how many meetings I've been in where you have the easels set up. And either the commission can see it and the public can't, or the public can't and the commission can't. You know, have a board, have something, have one of those roll around big boards that you can pin plans up to so people can see. Because I can't see that, all right? And once you get that kind of disruption, it grows, it never diminishes. Okay, who can speak at a public hearing? Who can't speak at a public hearing? Any ideas?
Everybody can speak.
Everybody can speak at a public hearing, okay? When we do this for Clear in Haddam, they have what they call clickers. People can pick multiple answers. Like one of the answers, you know, that convicted felons can't speak, or people from out of state can't speak. Everybody can speak, okay? And so that's easy, everybody can speak. We talked about the applicant going first, pro bonos, opponents take turns. You may get an intervention, an environmental intervention, or something called 22A-19. I'm not going to get into that tonight, it's too long a topic. If you get one of those, call the town attorney, which I think for all of you is me, or one of someone in Howland Sage. So by all means, they have the right to participate. An intervener has the right to participate, even if there is no public hearing. Okay? That's what you need to know, and that's why it's in there. You can allow people to speak even if there's no public hearing. Wetlands commissioners, DEEP tells you not to do that. The reason DEEP says that is because the statute says thou shalt not hold a public hearing unless ABC, okay? So they're worried that you'll end up holding an unnoticed and unauthorized public hearing. It's a legitimate concern, but if you've got 2 or 3 people who want to ask a question or something at a wetlands meeting and you haven't set it for public hearing, it's not a significant activity. I really don't think that's cross-examination, all right? Due process requires you to allow cross-examination of a witness, someone who spoke, all right? Now, if someone stands up and says, I want to cross-examine that witness, chances are it's going to be a lawyer. Doesn't have to be, but chances are it will be. And chances are even better that the lawyer is hoping you'll say no, because then they've got you on appeal. So, Chairman, the way you respond to that is, I want to cross-examine that witness. Well, Mr. Smith, we're kind of a small town. We do things kind of informally around here. We usually have questions asked through the chair. Is that okay with you? Now they have a choice. If they say, well, yes, that's okay with me, they've waived their right to cross-examination. If they say, no, I demand the right to cross-examine the witness directly, let them do it, because you've avoided an appeal, and the truth is, nobody ever got anything good out of cross-examination in an administrative hearing, okay? The only reason they do it is to try to get you to tell them they can't, really. So that's how you respond to that. Again, by the time you have lawyers on both sides, you should have your own attorney there, but just something to keep in mind. Site walks, especially wetlands folks, this is a big one. When you walk a site as a commission, it is a commission